Item number one. Here the major case 2 of 2025.
Lord, I appear for the petitioner, my lord.
I for the state.
It's an application for bail. Case diary?
Case diary has to be possible. Even I have knowledge that charge
No, no,
sheet
no.
has been served.
Let the case diary be clear. Charge sheet has been submitted. One of the accused has already been granted bail, my lord.
Even though case diary.
When you will be able to produce case diary?
Because on Friday or Monday, because it is from the north and middle.
Then it will be on Wednesday.
Lots.
Let it be on Wednesday,
Lots.
my lord. Don't record any order. Right. At the time of moving bail application, we are inclined to examine the materials available on case diary. Stop. Learned advocate representing the state has prayed for accommodation to produce case diary. Stop. It is also submitted that the police station.
Yes, Rangat.
Yes.
Yes, Rangat.
Oh, police station, concerned police station is Rangat, which situates at a remote area. Therefore, reasonable time is required to produce the case diary. Next paragraph. List the application at the top. List the bail application at the top on February 22. February.
Lord, I have also got the charge sheet, my lord. I'll bring that.
Right. এটা শোনো
मेरा पेन तो तुम्हारे पास है। मेरा पेन है कहाँ?
Item number 2, WPCT 44 of 2024. This matter my senior counsel Mr. Devanagi is appearing for the petition. Active matter is fixed on.
You are for the respondent.
Yes.
Yeah, who is appearing for the petitioner?
Sanjay Nag. Senior counsel.
Where is she?
From the court.
Not today.
Okay.
Not today.
Item number 3. Here 6 of 2024 with grant 1 of 2024. I'm for the responding state. Appeal against the conviction. Section 5 is.
Or it's the appellant. Yesterday appellant appeared and produced some medical document. No, that is different matter. There is a section 5 application.
Delay of how many days?
No, it is appealed by the convict. Conviction.
না তাও delay হয়েছে।
হ্যাঁ, delay
One
taken out.
month
Tick. What? Even we go to 1821 days.
Oh,
1821.
9 days.
No, but stamp reporter says it is 1821. Who is appealing for the appellant? Arun Prashant. In other matters also he is appearing. He is appointed by the state legal services authorities. But we never find that he is appearing in any matter. Always is another advocate comes on his behalf and prays for time. What is this? Then we are required to talk to the Secretary of State Legal Services Authorities. If this is the approach of the advocate appointed by the SLSA, then it is very difficult for us to hear the matters and pass orders. In all other matters, in one of the matters, we have passed an order having found that simply a section 5 application, it was required to be allowed, and we admitted the appeal. But in all matters, if this is the approach of the learned advocate appointed by the SLSA, then it's a very difficult situation. Do you have any contact with this Alokesh Sarkar? Where is he? Where is he? There should be a limit of everything. 1 day, 2 day, we can understand. Repeatedly, he will not appear, then we will direct the secretary's SLSA to take steps and engage other lawyers. Well, not today, not today. Inform Mr. Sarkar. Yesterday, if we do not find him, then we will be compelled to pass different orders. তাই তো? দেখো তুমি
না, প্রতিটা দিন time নেই।
in all matters you are appearing for the state, we find you every day. Not today.
Item number 4.
My lord,
29 of 2024.
at
Yes.
matter where my lord, I was seeking time to file reply in the condonation, but my lord had kept it today to see what the stamp reporter has mentioned.
Yes, yes.
Number of days ago.
This is your writ petition, appeal. Stamp reporter, just a minute, reporter দেখি কি করেছে। এই দেখো, এবার এসছে। 387 days দিলে আবার কোনো ফোন।
হ্যাঁ,
কি মানে হয় বলো?
এই seal and signature is required.
আর শুধু তাই না, কোয়ান্টিফিকেশন অফ ডিলে
হ্যাঁ।
ছিল না, এটা তো পরে add করেছে।
হ্যাঁ। So there is a delay of 387 days.
387 days.
387 and 84.
You want to file a reply? Already affidavit in opposition has been, in connection with section 5 application has been filed.
20th January it was served by.
But you are the appellant, you want to file a reply?
Yes.
Very good. Yes. Oh, no, no.
It was ultimate drafted, it was sent to the department.
Those things, that's what. You are for the respondent. What is the matter about Mr.
Section 37, my lord.
Arbitration?
So,
Arbitration against the order of the district judge. Appeal could have been admitted and very well. Since there is a direction by the coordinate bench, we should not deviate from the direction. Yes, what you are submitting? You are representing the respondent claimant. Respondent claimant? Yes.
Officially seen. Asking myself whether any reply is required at all.
No. Since there is a direction for opposition, it has not been directed by, it has been directed by the coordinate bench. So let the section 5 application be heard on the basis of the exchange of pleadings. Since already an order is there. Matter is taken up.
Leave to affidavit in opposition.
Yes, that's why the opportunity, right? Opportunity should be given to the section 5 application.
I shall not contest. Come to the main meeting.
You have filed in the department. The land advocate representing the respondent has submitted that in terms of the order dated 6 January 2025, affidavit in opposition to the section 5 affidavit, just the number to the affidavit in opposition to the application under section 5 of the Limitation Act being Can 1 of 2024 is filed in the department and same is on record. Stop. Next paragraph. Mr. Chakraborty, learned senior advocate representing the appellant has prayed for accommodation to file affidavit in reply. Stop. Let affidavit in reply be filed by 10 days from date with an advance copy upon the learned advocate representing the respondent. Next paragraph, list the matter before the next available circuit. Or list the matter before the next circuit, not available.
কোর্টে তো ডাইরেক্ট দিতে পারে এফিডেভিটের অপোজিশন রিপ্লাই গুলো আমাদের করে
চেয়েছে
হ্যাঁ
ও affidavit টা file করে
Item number 5. Effective of 994.
Who is for the appellant? Where is he? Well, not today.
Number 6. There is DB 3 of 994.
Appeal my lord against judgment of acquittal under the Prevention of Corruption Act. The state has filed an appeal matter along with an application seeking leave to refer the appeal. But leave to appeal is not automatic. It is subject to the satisfaction of the court. Grounds have to be satisfied.
Under section 378 2A, 2B.
Difficulty, what has happened, we can protect the appeals. The respondent accused matter. It is helping matter.
No, respondent, we understand. Your junior tried his level best for 2 days.
I suggest,
Now,
instead of
for-
filing an affidavit, let them file a informal paper book by tomorrow.
let us,
Depositions has to be on record because it has to be satisfied.
with regard to the grant of appeal, let us permit the, let us grant the leave. Let us grant the leave, let us grant the leave to file the appeal, let the order be tested. No, no, Mr. Tabrez, that should not, that is not expected.
Can be granted and the leave can't be granted, my lord. This is the case. Why should we waste the judicial time? This is the case when the complainant did not support the case of the prosecutor. And he said there was no demand, I did not give any money.
Since it is an order appeal against acquittal,
My lord.
so it is expected that an seasoned advocate like Mr. Tabrez will take this point. But the question is, it's an appeal against appeal against acquittal. Let the leave be granted. Let the paper book be filed. We will admit the appeal, and the appeal be heard on merit. And we will add a line, since you are taking this point, that all points are kept open to be decided. Yes, yes, yes.
But there are various factors that have to be considered by granting leave. One, there's wrong appreciation of evidence. It has to be demonstrated before the court.
Then what would be left for consideration at the time of hearing of appeal, Mr. Tabrez? If today,
If leave doesn't deserve to be granted, my lord, it has to be rejected.
if today, at the time of admitting or allowing this application seeking leave,
But my lord, dismissing.
if today, at the time of granting.
Roving inquiry into the evidence
Yes,
at
right.
this stage is not
Called for.
not declared.
No,
I have every satisfaction that
if today, we at the time of granting leave to prefer an appeal as envisaged under section 378 CRPC, if we examine this thing, these aspects and make certain observations, then what is left to be decided in appeal?
Tentative observations not affecting the decision on merits in the appeal, my lord. That would be my respectful submission.
yes, yes. Tentative always this order which will be passed at the
But this is satisfaction, whether it is reported. So it is something like that, an appeal grant into is that satisfaction. Have to subject to correction, my lord. You have to demonstrate and satisfy, my lord, what was the velocity in the order. Whether the trial was, what was not appreciated in evidence or what was contrary to law. I think there was two possible views and the learned judge has adopted one possible view, then this court will not interfere, my lord. That's the law, my lord. Let them satisfy.
But in that event, the right to prefer an appeal will be frustrated forever. It's a substantial right.
That is conditional, my lord, upon satisfaction. Had it been had the complainant come in and appeal.
Let us see the relevance provision.
Supreme Court.
Yes, my lord.
Where is the Supreme Court judgment? You have seen Supreme Court has framed some guideline, so us. In the circumstances, he will tomorrow. I said,
No, yes. Yes, it's a relevant consideration as you are submitting. Let us demonstrate before us that how our hands are tied to grant a leave, mere leave to file an appeal.
Depositions are not before the, on the court by law.
discussion on the deposition by the court below is before us.
The judgment of the letter trial court would be examined by the honorable court, taking into consideration the evidence that was recorded by law. The evidence has to be there before the honorable court, so as to assess and determine whether the findings of the trial court are legal and justified or not. With the deposition, my lord may comment, they not file informal paper. Let me be permitted to bring those depositions tomorrow, my lord.
Yes, you respond.
Let's see.
Deal with his
My friend is very happy.
deal with the point raised by him.
Time of this regarding evidence.
Yes.
It can be heard at the time of hearing of the appeal, lordship. There is no bar under section 378, that is surplus 1P. There is no first rule that without satisfying the court, leave has to be granted, lordship. Leave can be granted, lordship. Regarding that.
No, yeah, as Mr. Tavares submitted, it cannot be granted mere asking. You have to satisfy prima facie that there is a good ground to accept the appeal.
Lordship, there is a ground. Even though defective complainant did not submit the case of the prosecution before the trial court, lordship, but three trap laying officer, other independent witnesses was categorically stated how he has taken the 8,000 rupees as a bribe for clearing the bills for construction work. Even a complainant hostile slightly supported the case of the prosecution. Even though there are independent witnesses, total 11 witnesses were examined. Pre-trial proceeding was conducted. Recovery was made.
Okay, where is the discussion regarding the independent witnesses page?
And
Internal page?
They have not filed anything, that is what I'm saying.
No, judgment, from judgment. From judgment. Most probably the judge has dealt with the same. Who is the independent witness? PW7 has supported. Hmm?
also
PW2
PW2
has supported.
supported.
Who is the complainant?
No, complaint is the PW1.
PW1.
No demand.
Okay.
Which page, PW7?
PW7.
Eight, my lord, PW1. We complained.
PW7
Internal page 8.
internal. No, PW7 discuss page 20. Internal page 20 of the judgment.
Yes.
That is PW7, lordship. Internal 20.
Budh Bahadur. Budh Bahadur, on the next date, he attended office, went to my chamber, he found two clerks. Twenty-one.
That page number 10 also. will be-
21, he further said, complaint informed them that the person concerned, namely such and such, agreed to accept the bribe at his quarter at Kodamtala.
The page number 10 of the informed judgment.
Wait.
Page 21,
Lordship, page number
page
10.
21, yeah, third paragraph.
Just a minute. It was stated that the complaint informed person concerned only Rajesh Singh agreed to accept the bribe at his quarter. That is sufficient at this stage.
Sir, there are prima facie case to go.
That is sufficient at this stage, Mr. Tagrej. And please come to the relevant section, 378 subsection 3. It says that no appeal to the High Court under subsection 1 issue. That is in connection with 378 1B. Then the provision relating to granting appeal is contemplated under subsection 3. It says issue.
Yes, leave.
No appeal to the High Court under subsection 1 or subsection 2 shall be entertained except with the leave of the High Court. There nothing is provided that the High Court is required to form a privacy opinion. And in addition to that, taking cue from your submission, my learned brother has rightly pointed out that there is a material which appears from the deposition of PW7 Budh Bahadur.
The allegations is that there was a demand and there was a recovery. In consideration, under Prevention of Corruption Act,
Yes.
there is two things have to be proved in my knowledge. Number one, demand. Second is recovery.
Mr. Tabrez, we cannot shut the door of appeal at this stage. So far state is concerned, we know that in this field, in this particular field, you are a seasoned advocate. You are taking the right, you are taking the germane points, but we are expressing our view that since appeal is a substantive right, we are not inclined to shut the door of appeal at this stage. Let the order passed by the Sessions Court be tested. কি বলো?
Unless the demand is proved.
তুমি দেবে? দাও। দাও।
আচ্ছা, yeah,
এই যে এটা দেখো।
can, হ্যাঁ।
এটা দেখো আর এই
10/2 of 2024. This application has been filed under section 378 within bracket 3 of the Code of Criminal Procedure seeking leave to prepare the appeal
আস্তে 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 আস্তে।
against the judgment of acquittal passed by the learned session judge at Port Blair in special case number 4 of 2025 corresponding to special sessions trial number 18 of 2018. Stop. Acha, Mr. Your name,
Tabrez, Mr. Tabrez.
your name, Acha, Mr. Kormakar, learned advocate representing the appellant applicants, submit that the appellant has made out a good ground in this present appeal, and accordingly, a leave may be granted to the appellant to proceed with the appeal
Under section 373.
under section 378(3) of the code. Stop.
Of CRPC code.
Of CRPC. ঠিক আছে. Per contra, Mr. Tavares, learned advocate representing the
Not Tabrez, Tabrez.
representing the respondent,
Yes.
submits that here the case was started under the Prevention of Corruption Act. 13(2). 13(2) of 7 and
And 30.
7
Section 7 and 13
13(1)(d) and 13(2) of the Prevention of Corruption Act.
1980.
1988. He submits that he contends that the prosecution has failed to the case beyond any shadow of reasonable doubt, and even the de facto complainant was the star witness of the prosecution did not support the prosecution case. Even the prosecution stopped event prosecution stopped. He submits that leave cannot be granted on mere asking, and
Leave cannot be granted on mere seeking, on mere filing the application unless the prima facie satisfaction is expressed by this court while considering the application seeking such leave.
stop. আচ্ছা, এবার আমাদের admittedly At the stage of dealing with such application, its court should not go into the roving inquiry as to whether the prosecution case has been proved or not, and at this stage it is not possible to reappreciate the entire evidence. Stop. The only scope of inquiry shall be confined as to whether the appellant has made out a good prima facie case to proceed with the appeal or not. Stop. ঠিক আছে, and for this purpose we have perused the for this purpose to ascertain to find out the answer to this query, we apply our mind to the order impugning the appeal and the materials on record. ঠিক আছে, আচ্ছা, stop. Though the de facto complainant has not supported the prosecution case, but other tap witness has deposed against the accused person. Huh? Appears as
Right.
appears to have deposed against the accused person. Stop.
That's why we had set our mind that you should not invite this court to pass an order on expressing satisfaction. That may prejudice you in appeal. That is the difficulty.
So considering this aspect and upon perusal of the materials on record, we have of the view that
Now, upon the material, we are inclined to grant leave as required under section 378 subsection 3 of the CRPC. So accordingly, the
leave is granted.
Hence, the leave is granted and the connected application being দেখো তো application নাম্বারটা
Can 1 of 2000
connected application being CRAN 2 of 2024 is allowed and disposed of.
let the appeal be heard.
না একটা ফরমান আছে stop. Next paragraph indicate the heading CRA 3 of 2024. Next paragraph. First paragraph. Appeal is admitted. Appeal is fit for admission. Stop. Accordingly, the appeal is admitted. Stop. Let trial court records be called for. Stop. Paper book in requisite number shall be prepared by 6 weeks from the date of arrival of records from trial court. Stop. Department is directed to issue notice. No, all are present. So trial court record, that line is not required. Stop. Parties shall be at liberty to mention the matter before the appropriate bench for expeditious hearing of the appeal after appeal is made ready for hearing.
ওটা হচ্ছে টাইম to have from the date of arrival of lower court record. 6 weeks from the date of arrival of the
Yes, that I've said.
now lower court cannot be set a trial court record.
There is Supreme Court judgment.
ট্রায়াল কোর্ট করে দেবেন, আমরা যদি লোয়ার কোর্ট
Yes.
Apply.
Now fight out your case full on.
I want to absolutely clear. Yes.
Yes.
Oh.
Yes. But you have got enough time. As it appears from the orders passed by the coordinate benches.
Dialysis going on.
Hello,
Item 7.
not today. You are appealing for the writ petitioner? You are for the respondents? Maybe we did not. Hello? After transcribing this order, send this order to.
Pending.
For correction. Who is for the petitioner? Not today.
Item number two.
Why? Who is for the petitioner? You are for the petitioner? Not today.
Three. Something of 25.
Yes, you have come. Who is appearing for the petitioner? Who is for the petitioner? Yes. So you are ready to place the matter? Very good. Serve the copy. I am directing him to serve a copy by today.
Let the matter come to.
Why? See, same order is to be passed, which was
I have to take. I have found.
see, usual matter and application. Mr. Mishra, usual matter.
Already. And they are applying for it. It is so then that can be decided, application can be decided.
Usual matter.
Let them, at least let them serve lordship. They have made the party to the department.
Since it has not been solved. He is taking this point tomorrow, not today. In the meantime, you will serve or record an order. Record an order. At the time of call, Mr. S.C. Mishra, learned advocate representing the respondents, has prayed for accommodation since copy of the writ petition has not been since he is not having the copy of the writ petition. Stop.
Copy is not served to the department.
Copy was served upon learned advocate. You want instruction to be taken from. Oh.
Sir, they have made the party lordship.
No, it has been served upon you.
Upon me.
Has it been served upon you or not?
It has been served
Put it down.
on.
At the time of call, learned advocate representing the respondents has prayed for accommodation to obtain instructions. Stop. List the matter under the same heading tomorrow.
Lordship, in the meantime, let them serve.
It's not required. Since you are appearing, you take instruction. It has been service has been effected upon you.
Next time onwards, I will not take the copy lordship, because this is the tendency, it is very difficult for me to, because material, while taking material instruction, I have.
Next matter.
Item number 4.
Same. You are appearing tomorrow, same order. Tomorrow, we will obtain instruction, Mr. Mishra.
I am appearing for the respondent.
Yes, Mr. Mishra, have you taken instruction?
Lordship, please, kindly come to page number 21, Lordship.
Yes.
We have not received this application, Lordship. No official seal is there.
That's because the seal is not there, the learned senior is making the submission. Actually, when the.
No, I have taken
But
instruction, it has not been.
when the petitioner went to give the same,
Hey,
they have signed the same, but has.
give a copy of the order. আগের দিন দিয়েছিলেন না একটা order আমাকে? Well, I will grant him leave to make an application within time and based on which decision to be taken. Just a minute. এই order কালকে যে দিলে the order copy দাও তো। Where is that order? Yes, rightly pointed out. There is no receipt.
Only got a seal, seal is not there, Lord. But the signature of the.
No, I have taken instruction from the authority.
I received the affidavit of the one. Already, sir, we have waited for 2.5 months, got it, and after that, we have come to the one. And this is only for grant variation. Leaving out what you are leaving the family.
Stephen, this paragraph will remain same, then this paragraph will be, will follow in this paragraph, and paragraph 3 has to be changed. Yes, take down. Paragraph 3, the grievance of the petitioner is non-supply of electricity on installing meter, and at present petitioner is living without any electricity. Next paragraph. Having perused the application and in consideration of the submissions made on behalf of the parties, this court finds no useful purpose will be subserved in keeping the matter pending. Stop. Hence, writ petition stands disposed of, directing the concerned assistant engineer, being respondent number 3, no, hence writ petition stands disposed of, strike it off, disposed of, granting leave to the petitioner to make a formal application for new electricity connection before the before the concerned assistant engineer, being respondent number 3, by 7 days from date. By 7 days or fortnight, by 7 days from date. Stop. If such application is made by the petitioner, in that event, respondent number 3 shall decide such application in accordance with law by fortnight from the date of receipt of such application, and the decision to be communicated to the petitioner by 1 week thereafter. Next paragraph. The concerned assistant engineer is required to pass a reasoned order in the event petitioner's application is rejected. Certified comment. Disposed of. Oh, right.
Item number 6, 7, 8 is not pertaining to.
Just a minute, let it be called down one after another. মনে হচ্ছে এটা একটু দিয়ে দাও, এখানে লেখাটা আছে পারবে না।
Item number 6, WPA 25 of 2025,
Not pertaining to the electricity.
He has spent in Tamil Nadu for his medical treatment, and he will be returning on 5th of February. So I pray that the matter can be
ইলেকট্রিসিটি নয় বলছে।
fifth personal round of the Learned Council of the Report.
It's not an electricity matter. At the time of call, accommodation has been prayed for on behalf of the petitioner on the ground of the learned advocate. Next paragraph. He will return back on 5th. List the matter under the heading motion. On 6th February 2025. It's not electricity matter. Yes, very. No, it's an electricity matter, but not the usual matter. Yes. At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph. List the matter under the same heading. Or simply not today. Simply not today. Don't pass any order.
Number 8, WPF 40 of 2025.
Electricity. No, not today. Inform Mr. Misro. Inform Mr. Misro that these two matters are electricity matters.
Item number 9, CPS 37 of 2024.
Who is for the applicant? Not today.
Number 10, WPF 63 of 2019.
Not today. Go on calling.
Item number 11, WPF 40 of 2022.
Not today.
Item number 14, WPF 3 of 4 of 2022.
Yes, Mr. Chakraborty. 14, you are appearing. For the respondent or respondent? You are representing the respondent, petitioner.
Because labor court might not what is challenge. It has to be decided by not both parties.
But Mr. Vijay Kumar appeared last occasion for the respondent.
He was making his on his behalf, a request was made that he has gone to Chennai and is coming back on the 5th
On 5th.
from the earlier matter.
So Vijay
While
Kumar
this also can be kept by the-
represent the respondent. Also seeks information of the record of origin. For purpose for person there is a direction to file affidavit in opposition last occasion. But no opposition has been filed. Not this week. Not this week. Today I will not pass any order. Not this week.
Number 15, WPF 407 of 2022.
Today it appears that the time is not suitable. Before different courts.
Union might not have is regarding representation in a particular might not.
Well, Vinita, last occasion one Vinita Devi appeared on behalf of Binnu Kumar. Not today, not today. He was there when we were sitting in the division.
I got respondent for union.
Yes. Well, you have filed it, filed it.
Not today,
Not today.
WPA 862 of 2022, item number 17, WPA 930 of 2022.
Not today.
Item number 80, WPA 194 of 2023.
Not today.
Item number 19, same matter.
Not today.
Item
Call one to another in this, not in this fashion. Yes.
20, WPA 42 of 23, within 21.
Not today.
22, WPA 593 of 2023.
Why? Remaining matters?
Some matters, especially for
You are appealing on whose behalf? Mr. For the writ petitioner. Not this week.
Number 23.
Not today.
Maybe given a you have to say affidavit is declared, petitioner will come on.
Not this week. Not this week. This is item number 20, 23. Not this week. Yes, not this week.
Item number 24. Item number 25.
Not today. Not today. Not today.
Number 26. WPA 702 of 2023.
Not today.
26.
Senior is appearing for the sworn in. And therefore.
26. This is item number 26. Yes. What? Where is your senior?
Shiva Balan, a very submissive lawyer with one brain. How many matters you would do in the next?
Sivabalan.
It is very submissive. How many matters are being, how you do I just tell you?
Not this week. Same point would be taken when you will pay for time.
Take time, not every time.
Yes.
WPA 88 of 2023.
Petitioner. Not today.
Item number 29. WPA 890 of 2023.
28 time was obtained. 28. Yes, yes. Item number 29.
59. My lord, I am appearing for one of the respondents. That is Sivabalan about.
Yes. Where is he? Not this week.
Item number 30. WPA 902 of 2023.
Private respondent. Mr. Sivabalan. Not this week.
Some matters, when in access to Mr. Shiva, we can start here. We can note down, no problem more.
Item number 31. WPA 907 of 2023.
31. Yes. Not today.
Item number 32. WPA.
Not today. Tell him to appear tomorrow. Yes, 32 and 33. You are for the respondent.
Yes.
Yes. Yes, yes. Next.
Number 34. WPA 953 of 2023.
Petitioners. Not similar matters before our situation bench also. But we have to find our affidavit in reply.
Similar matter means what is the matter about?
Between the same parties. This is between the same parties.
Issue is same.
So issues are different, but parties are same.
Maybe.
Request is the same.
Request is the same because the petitioner is not in town. He is in Chennai for a statement. So we are unable to, because we need his signatures to.
For filing affidavit in opposition. Reply. They place the matter. When your client will come back,
He said tentatively 2 weeks, but last circuit also he was not present. That's
then
why-
let me see. What is the last one?
But same, the other matter also went to the next circuit.
Division, before the division bench. So you have filed your opposition. Record an order. Learned advocate representing the petitioner. This is item number 34. Client advocate representing the petitioner has prayed for extension of time to file affidavit and reply. Stop. Next paragraph. Time to file affidavit and reply stands extended by 3 weeks. Stop. list the matter before the next available circuit after the time fixed herein above for filing affidavit in reply.
Number 35, WPA 965 of 2023.
My lord, senior during Ran is appearing on behalf of the Krishna, my lord. 2 weeks time may be given, my lord.
Your senior is just standing behind you. First time extension or it has been extended previous? You are representing all the rest? No. You are representing which respondent? Petitioner. So you want to file opposition on extension, reply, opposition has already been filed, time for filing. So all the respondents have filed opposition. Land advocate representing the petitioner prays for extension of time to file affidavit in reply. Next paragraph. Time to file affidavit in reply stands extended by 2 weeks. Stop. Next paragraph, list the matter before the next available circuit under the heading hearing, capital H, under the heading hearing, quote unquote, after the time fixed herein above for filing affidavit in reply on extension. Next.
Item number 36.
Petitioner has not been appearing for very long. Maybe sir, let me see the docket sheet. Potential not to be for long.
Actually, the thing is that they wanted to protect the demolition of the structure. The municipal council has found that the building is in dilapidated condition. So orders were passed and they wanted to protect it. They filed the writ application, no interim order was granted in their favor. And building has already been demolished, they have been removed from the premises.
Once Husnas Banu appeared on behalf of Phutik Chand Das. Where is he? Not this one.
Item number 37, WPA 100 of 2023. Item number 38, 39, 40, 41.
My lord, 37 and 39, I appear on behalf of the respondents. My lord, I have already filed my affidavit of opposition.
These bunches of matter lordship on remand. In the first round, writ was dismissed. In the intra-court appeal lordship, the order was set aside, it has been remanded back, giving them an opportunity to file your petition.
I have filed.
Mr.
In
Shiva is
respect of
saying-
item number 37 and 39.
That can be taken up.
37 and 39, you have filed your opposition.
My lord, I am.
But what about the opposition in other matters, since on remand matter is to be heard on exchange of affidavits?
Regarding the other matters, my lord, Mr. Shiva Balan is appearing on behalf of the respondents.
2 weeks time may be granted. But the time so accorded by the division bench lapsed. The time so accorded by the division bench.
At
lapsed.
least this case, it is better case before this court that the division bench is directed to that the matter to be heard on affidavits. In other matters, we are extending the time on prayer of the learned advocate. Here court is fortified by the order of the division bench.
If Balor would still not have challenged the order on several grounds. Opportunity hearing is one of the grounds. But finds that on that ground, the order can be.
In which matters Mr. Sibabalan is appearing 38, 40 and 41. But in last occasion, I find that orders were passed on 2 separate orders. Last order was passed. Oh.
38 में नाम नहीं दे रहे 38 हम 37 और 39 में हैं
सॉरी 39 में इसमें नाम नहीं आ रहा है 37-39 बस
अच्छा
आप सब बोल रहे हैं कि बिल कटा में दोनों का नाम एक ही मैटर में आ रहा है उसमें मुश्किल है
না কিন্তু এখানে তিনটে ম্যাটার বলছে
कंफ्यूज हो रहा है एक ही मैटर में हम लोग दोनों का
কিন্তু এখানে দেখছি চারটে ম্যাটার 2 3 4 5টা ম্যাটার টোটাল 5টাই আছে এখানে নো 4টে ও 37 record a note on indicating 5 writ petitions in connection with the writ petitions being WPA 1001 of 2023 and WPA 1004 of 2023. Learned advocate representing the respondents has submitted that affidavit in opposition, affidavits in opposition have already been filed. Stop. Next paragraph. However, learned advocate however, on behalf of the respondents in WPA 1002 of 2023, WPA 1010 of 2023 and WPA 1013 of 2023. Further accommodation has been prayed for to file affidavits in opposition. Stop. It is submitted that the learned advocate representing the respondents in these 3 matters is out of station. Next paragraph. As a last chance, time to file affidavit in opposition stands extended in these 3 matters by 3 weeks. Stop. Let all the 5 writ petitions appear under the same heading before the next available circuit after the time fixed herein above for filing affidavit in opposition. But you don't want to file reply.
I
Yes,
was about to make submission. So far as the opposition wish.
you have filed reply.
You know, let it be a comprehensive order for all repetitions.
No. Please read the first part of the order. Stop. Yeah, it is also submitted by Mr. Mr. Jaipal, learned advocate, representing the petitioners, that affidavits in reply have also been filed. Have, oh,
I have not yet filed it. I have not used it.
oh, I see.
Not yet used it.
না তাহলে এখানে strike it off. Then please go on reading. Stop. By 3 weeks. 3 weeks. Stop. Stop. Mr. Jai, next paragraph. Strike it off. Let. That line would be should be struck off. Next paragraph. Mr. Jaipal, learned advocate representing the petitioners in all the 5 writ petitions, has prayed for leave to file affidavit in opposition separately. Affidavit in reply separately.
Yes.
Has prayed for leave to file affidavits in reply after affidavits in opposition to be filed in the aforesaid 3 matters. Stop. Time to stop. In the event affidavits in opposition in aforesaid 3 matters are filed within the time fixed by this court today, petitioners shall be at liberty to file affidavits in reply by 2 weeks thereafter, or by 3 weeks thereafter. Next paragraph. List all 5 writ petitions as analogous matters before the next available circuit after the time fixed herein above for exchanging pleadings on extension of time.
But may I say one thing, kindly cut short the time for me. 1 week is enough. Instead of 3 weeks, let it be 1 week for.
Very well, 2 weeks. 2 weeks. Reply 2 weeks.
Kindly.
Item number 42. WPA 1003 of 2023.
It's one and same with that of the previous matters.
But it-
41, it's 42 is a same matter. It's not been tagged with these matters, but the common question of facts, it's an ideal question of facts.
Yes, what is the position with regard to filing of?
Position is not defined.
Where Mr. Sivabalan is appearing? Opposition has been filed. Yes, opposition has been filed. Yes, it is on record. Yes, find it out whether it has been.
Yeah, you-
So I am extending the time to file reply. Learned advocate representing the petitioner prays for time or prays for accommodation to file affidavit in reply. Stop. Let affidavit in reply be filed by 2 weeks. Stop. List the matter before the next available circuit under the heading hearing, quote unquote, after the time fixed herein above for filing affidavit in reply.
Like,
Item number 43. WPA 1026 of 2023.
My lord, Mrs. Naz is appearing on behalf of the petitioner, my lord. I pray for a short passover, my lord.
Not today.
Item number 44. WPA 1068 of 2023.
I'll use my reply, they have filed the opposition. This requires some more time.
Why if reply and oppositions have been exchanged,
I have not been filed.
you want time to file reply? Let me see the record. At the time of call, learned advocate representing the petitioner prays for extension of time to file affidavit in reply. Stop. However, administration is represented by learned advocates. Next paragraph.
Private, my lord.
However, respondents are represented, because, not administration, respondents are represented by learned advocates. Next paragraph. Time to file affidavit in reply stands extended by 2 weeks. By 2 weeks. Next paragraph. List the matter before the next available circuit after the time fixed herein above for filing affidavit in reply on extension of time. Yes.
Item number 45. WPA 1072 of 2023.
Not today.
Item number 46. WPA 81 of 2024.
Now, pages, the opposition has been served. This was brought to the notice of this court and the respondents were directed to supply the.
46.
46.
Who is for the petitioner?
I'm there.
Who is for the respondent? Where is she? So, the entire copy of the affidavit in opposition, including those 2 pages. Not today. Not today. Not today. In the meantime, if it is possible, third copy, entire copy of the writ petition, copy of the affidavit in opposition, including the pages, 2 pages, to enable the learned advocate representing the petitioner to file reply. Come back tomorrow.
The interim order was still yesterday. So this has to be extended for another day. So it's coming up because not to see last order, it's for 20th February, but you have to the interim order is made operative. Today being the 29th, it has to be extended.
I thought it's a month of February.
It is 28th February.
Sorry, I thought it's February.
Come back tomorrow.
My lord.
You serve a copy. Better let it be on 5th. In the meantime, you serve copy and let me see. Not this week, not this week. Item number 46, not this week.
Item number 47, WPN 19 of 924.
Petitioner? Yes.
Mr. Binu Kumar appears to. क्या बोल रहे हैं?
Not today.
Item number 48,
Not today.
item number 49, WPN 6 of 924. I'm for it.
Respondent? Affidavits have been exchanged. My name. Has joined the court for. Yes, what about your affidavit, Ms. Das? So you don't want to file any affidavit? So you are not interested to file any affidavit?
I can start with it soon. I can start following.
But what about the private respondent?
To serve. This would by order dated first.
So serve a notice.
They need to keep the requisites.
Yes, today's when the others are getting this benefit, why he will not get? Serve a notice, Mr. Jaipal, serve a notice upon Mr. V. Narayan, representing respondent number 4 and 5.
Hello.
4 and 5, I am fixing this matter on 5th.
My
No further extension is required. Whether the private respondents have filed affidavit, no, we will record an order. At the time of call, petitioner and administration are represented by learned advocates. However, respondent numbers 4 and 5 are not represented. Stop. Next paragraph, Mr. Jaipal, learned advocate representing the petitioner, submits that in spite of opportunity given by the coordinate benches to file affidavit till date, to file affidavit in opposition till date, no affidavit in opposition has been filed by respondent number. Affidavit in opposition has been filed on behalf of respondent numbers 4 and 5. Stop. Ms. Das, learned advocate representing the administration, has submitted that administration will not use any affidavit in opposition. No, it's up to you. After the hearing is progressed to some length, if this prayer is made, then I will not permit. Yes. What I was dictating? Administration is not use any affidavit in opposition. Any affidavit in opposition to this writ petition? Stop. Therefore, no further opportunity shall be granted to the administration to use affidavit in opposition in this matter. Next paragraph. Next paragraph. Since respondent numbers 4 and 5 are not represented today, learned advocate representing the petitioner is directed to serve notice enclosing copy of this order upon the learned advocate representing the respondent number 4 and 5 by 31st or yes by 30th January 2025. Stop. Next paragraph, list the matter under the heading hearing on 5th February 2025.
Blair.
No, if the interest of the administration is not involved, you may not use affidavit in opposition. Very good.
Item number 50.
I'm the respondent.
Mr. Stephen, do one thing, the second paragraph regarding her submission, that henceforth she will not, the administration will not be permitted to file any affidavit in opposition, strike it off,
Okay.
Yes.
strike it off.
Item number 50. WPA 136 of 2024.
I'm the respondents, all the respondents.
Yes,
Have to file the reply matter, I was auto distribution. It was Wednesday,
Three do not,
I was.
Manus, reply petitioners,
the order.
late matter.
Wednesday,
You are Prakash Minj. Used of the application and go to admin, go to file. Land advocate representing the petitioner prays for 1 week time to file affidavit in opposition, affidavit in reply. Stop. Let affidavit in reply be filed by February 2025. Stop. List the matter under the heading hearing on 6th February 2025. Let affidavit in reply be filed by 5th February 2025 with advance copy upon the learned advocate representing the respondents. Next.
Item number 51. WPA 167 of 2024.
I'm appearing as a respondent. Mr. Tabri, Mohammed Tabriz appears for the petition. He did not
Not to
mention,
be-
not to.
Item number 52. WPA 198 of 2024.
My lord, in the for the petition. I pay for short answer.
Not to be.
Item number 54. WPA 203 of 2024.
I appear on behalf of the already filed my.
Private respondent.
You are for the respondent. And
Private respondent.
who is for the petitioner? Who is out of station? Not this week.
Item number 55. WPA 207 of 2024.
My lord, it's not be sustained on behalf of the petitioner. Time may be given, my lord, we need to file a reply.
Let me see. You have filed your opposition. Learned advocate representing the petitioner has paid for extension of time to file affidavit in reply. Stop. You are representing PBMC.
Yes, my.
Port Blair Municipal Council is represented by the learned advocate today. Stop. Next paragraph. Time to file affidavit in reply stands extended by 2 weeks. Stop. List the matter under the heading hearing after the time fixed herein above for filing affidavit in reply on extension of time.
Item number 56, WPA 221 of 2024.
You are first respondent. But the last occasion also time was extended on 13 January 2025. How long this will go on? As prayed for as a last chance, time to file affidavit in reply stands extended by 2 weeks. Stop. Next paragraph, however, respondents are represented by learned advocate. Next, learned advocates, next paragraph, list the matter before the next available circuit after the time fixed herein above for filing affidavit in reply on extension of time.
Item number 57, WPA 224 of 2024.
Yes, not today.
Item number 58, WPA 227 of 2024.
Yes, 58. Mr. Jaipal, you are appearing. Yes, opposition is on record. Next, as prayed for on behalf of the petitioner, time to file affidavit in reply stands extended by 2 weeks. Stop. Respondents are represented by learned advocate today. Next paragraph. List the matter before the next available circuit after the time fixed herein above for filing affidavit in reply on extension.
Item number 59, WPA 229 of 2024. Same is the
Similar matters. Same order. 2 weeks.
Item number 60, WPA 235 of 2024.
Yes.
My lord, my senior is appearing for respondent authority.
PC Das is appearing for petitioner who requested me to play for an adjournment to next.
For the petitioner. At the time of call, accommodation has been prayed for on behalf of the petitioner as well as respondents. Stop. It is submitted that the learned advocate representing which respondents?
All respondents.
All the respondents. No, there are private respondents as well as official respondents.
No, official.
1 to 5. Yes, 1 to 5. Right. Official respondents. And what I was representing representing the respondents numbers 1 to 5. Now, it is submitted on behalf of respondent numbers 1 to 5 that the learned advocate is out of station. Next paragraph. List the matter before the next available circuit.
Item number 61, WPA 254 of 2024.
Yes.
So that I'm not doing, for, alternative land can be allotted in favor of the commissioner. Since the original, the air, legal air of the original allotting the one, it will take some time because he has to search out for, need land, government, revenue land.
The pain which my madam is saying, I know where the properties are there. I can identify them. I can identify, I know that. Where are the properties?
An extension is sought for submitting the reporting.
Whether
How much time is required to file the report? Because there was an extension on 6th December and subsequently on 9th January. It's-
or the maximum of submerged.
Where the lands are, where huge part of this union territory lands are available. That is known by Mr. Jaipal very well. So tell the concerned Tehsildar to consult Mr. Jaipal. Yes. A land advocate representing the respondents has prayed for further accommodation to file a report in terms of the order dated 5th October 2024 passed by a coordinate bench. Stop. Time to file report stands extended by 4 weeks. Stop. List the matter before the next available circuit after that time fixed herein above for filing report.
Item number 62, WPA 256 of 2024.
In this matter, my senior is appearing for the petitioner. I pray for 2 weeks' time may be granted for to file our affidavit in reply.
देखिए आप फाइल करना। As prayed for on behalf of the petitioner. Time to file affidavit in reply stands extended by 2 weeks. You have next paragraph, list the matter before the next available circuit under the same heading.
Item number 63, WPA 216 of 2024.
You are for the respondent. Not today. No one appears. Yes. Not today.
Item number 64, WPA 262 of 2024.
My lord, in this matter, Mrs. Naz is appearing on behalf of the petitioner, my lord. We have to file a reply, my lord. 2 weeks' time will be given.
Respondent administration.
Not sure if opposition has been filed, my lord. I've been told that it is filed, but is it there, Mr.? Yes. Is there, my lord?
as prayed for on behalf of the petitioners, time to file affidavit and reply stands extended by 2 weeks. Next paragraph, respondents, which respondents you are representing, Mr. Chakraborty?
All the rest.
Respondents are represented by learned advocates. Next paragraph, list the matter before the next available circuit under the same heading.
Item number 65, WPA 266 of 2024.
Already have filed the application.
Reply,
On their notice having released service, I filed service. But if they are not filing, because I'm told Mr. Abdul Prashant, the appeal in same has also been recorded, he's in court number 2. If they say that they will not file, cross that and go for filing reply.
well, not today.
On this one.
Opposition by the official respondent has filed opposition, but the private respondent has not filed opposition. That's why yes, private respondent has filed opposition. Respondent number 4.
Copy machine, because I was under the impression that they will not file.
Just a minute. No, 4 is the private respondent. On behalf of 4, opposition has been filed. Well, not today. Let Mr. Prashant, whether Mr. Prashant is representing all the respondents for private respondent. And Ms. Das is for respondent number 1 to 3. They অনেকগুলো respondent আছে। Not today. Up to 65. Any other matters till 90? Where it needs to be heard. Otherwise, there will be less matters in the list tomorrow. That I don't want. Yes.
Monday and Tuesday for some interpretation. So this is the matter with regard to the.
Who is appearing for the respondents?
I am there, but Miss Nag is the main respondent. IOCL man.
Well, not today. Let it be there in the list. Tomorrow it will be called, taken up.
Your worship, let me start with the matter because this agency in the sense that my distributorship is simply suspended.
No, it will be taken up tomorrow. It will be fairly at the top in the list.
But can it be specially fixed for?
Hearing matter, I will not specially fix.
Because I'm candidly, I'm saying what would happen is again tomorrow.
Miss Nag is here, my lord.
Yes.
I can start.
Now,
Item 79, WPA 425 of 2024.
Then the matters be called on serial. Otherwise, this will not call the matter serial from 65.
Item number 66, WPA 273 of 2024 with item number 67, 68.
66, my lord.
Just not, I've been made a request for this.
Not today.
Item number 69, WPA 300 of 2024.
Hearing is appearing for respondent of.
Who is for the petitioner? Not today.
Item number 70, WPA 301 of 2024 with item number 71.
My lord, my senior Vishal Kumar Biswas is appearing on behalf of the petitioner, my lord. Reply is ready, my lord. In the next week, we will file a reply, my lord.
Not this week.
What's up, then?
Item number 72, WPA 318 of 2024.
72.
We have filed our affidavit now.
Who is appearing for the respondent?
Respondent means senior. For petitioner.
Petitioner, who is appearing for the respondent? देखिए फाइल का दाव Yes, Mr. Adu Prasant is appearing.
Seventy-two.
It's time to file open opposition. You have filed your opposition. Not today.
Item number 73, WPA 327 of 2024.
My lord, in this matter, my senior Vishal Kumar Biswas is appearing on behalf of the petitioner, my lord. 2 weeks time may be given, my lord. We need to file a reply.
देखिए. You are for the administration.
Yes, madam.
Where is Mr. Ojoy Majhi appeared on behalf of Angelina.
Vishal Kumar Biswas, my lord.
Vishal Kumar Vishwas.
No, I have also been engaged in this case.
The advocate on record.
Insist your lordship, it can be taken up next week.
I am not
My
said it.
reply is almost ready.
I am not saying it. I'm happy to do the matter, but otherwise also fine, ma'am. Whatever your lordship do.
On 14 January, time was granted to file it.
What I suggest-
So now there is a change of advocate.
No, advocate on record is Vishal Biswas.
There's no change in that. Actually, he was unwell, so Ajay Majhi represented him.
At the time of call, accommodation has been prayed for on behalf of the petitioner to file affidavit in reply on extension of time. Stop. Next paragraph, time to file affidavit in reply stands extended by 2 weeks. Stop. The next paragraph. Respondents are represented by learned advocate. Next paragraph. Release the matter before the next available circuit under the same heading after the time fixed herein above for filing affidavit in reply on extension of time. Next.
Item number 74, WPA 329 of 2024.
Is the last order. It could have a bearing on this case.
You are for the petitioner. Review petition before.
An appeal was preferred by them. I think that they have not been given opportunity. When appeal was dismissed, but they were granted liberty to file a review application. They filed a review application in those cases. Issue is the same. Now they are saying that as the review application is complete, this matter also will be taken up after the disposal of the.
That is the order, my lord.
That is the order of the review order.
On account of in this position of the market. No, simply adjournment recorded. As prayed for.
So there is an order.
Have you filed your reply? There was an order passed on 4th October 2024. Reply that you will be filed. You don't want to. Opposition is there. You have filed your opposition. You have filed your opposition. You have filed your opposition. Yes, reply. So have you filed your reply? Tell me the review number. Review. Tell me the review application. I will place it before the division bench.
No, that, review is not before division.
Single bench.
We have
Review application. Oh, I thought that after dismissal of the appeal, review petition was taken out before the division bench. So on the since the review petition is to be moved before the single bench, appeal was dismissed or disposed of. Appeal was dismissed or appeal was disposed of. granting liberty to the appellant to file a review application. So review is to be heard by the particular bench.
As states from the order passed by the single judge in Calcutta. So therefore, since we have preferred a review, we made a prayer before this honorable court that let this matter stand over till that is decided. Because then there will be clarity on what the legal position is. Review petition number 5 of 2024. Review RVW 5 of 2024.
Recorder number. At the time of call, Mr. Shatadru Chakraborty, learned senior advocate representing the respondents, submits that a review petition being RVW 5 of 2024 pending before the coordinate bench for consideration. Stop. It is also submitted that such review petition has been taken out pursuant to the leave granted by the Honorable Division Bench. Stop. Next paragraph. According to the learned advocates representing the petitioner and the respondents, the issue involved in this writ petition touches upon the issue involved in the review petition. In the review petition. Stop. A joint prayer has been made on behalf of, next paragraph, a joint prayer has been made on behalf of the parties to adjourn the matter till review petition is heard. Stop. Next paragraph. In view of pendency of the review petition within bracket RVW 5 of 2024, close bracket, hearing of this writ petition stands adjourned for 8 weeks in order to enable the learned advocate representing the respondent / review applicant, respondent / review applicant to take steps for hearing of the review petition. Fine. List, next paragraph, list the matter under the heading, list the present writ petition under the heading hearing after 8 weeks before the next available submit.
Fine. Number 75, WPA 33 of 2024.
Who is for the petition? Your senior? Not to the.
Item number 76, WPA 340 of 2024.
This is a case where the application for diversion of land has been pending before the subdivisional officer for last more than 5 years. Now, the story goes like this. The petitioner purchased a property. The total area was 2.02 hectares. His intention was to construct a hotel or resort in that particular premises. He submitted an application for diversion of land for around 500 square meters initially. That was allowed. Now, whenever, Your Lordship, such applications are filed, a report is called for from the Tehsildar. And in the report, the Tehsildar is required to submit whether the land is suitable for agricultural purpose or not, and whether it can be diverted into commercial or not. Tehsildar submits a report saying that it is not suitable for agricultural purpose, and therefore the authority, after considering all relevant factors, used to pass an order with regard to diversion of that land. Now, 500 square meters was initially diverted. Thereafter, again 500 square meter was also allowed. So total 1000 square meters of land has been allowed in favor of the petitioner for diversion of land. The total area is 20,000 square meters. Now, the petitioner found that this is not sufficient. He wants some more. So he submitted an application before the authorities in 2020 as well as in 2022 also. These applications are pending. They are not adjudicating the application. They are not passing any order with regard to that. Now, as per the regulation, it says that if the application is not rejected, it's very specific, time limit is not fixed. But if it says that if the application is not rejected, till now my application has not been rejected. Then by taking premium from the person concerned, the land will be diverted into commercial. That is the law which says like that. Now the subdivision officer, what he is doing, he is neither rejecting my application but always interfering with my possession. Means
No, but 1000 square meter has already been diverted, which you are in possession.
yes, rest also
On which you are in possession.
But for the
But
rest,
your further application for diversion of another 1000 square meter.
that is
Now, to the your right to possess and enjoy the land of diverted 1000 square meter, nobody can obstruct you. So
not
why
able
the
to do anything on the remaining part of the land. It's
yes,
lying
it has
vacant.
not been diverted.
Yes.
How you can do this?
But my contention is that as per the regulation, it says that if it is not rejected, then the SDO is required to take premium from me,
Who HDO
subdivision
sub
officer.
SDO.
So now the problem is not this
If
part,
application is kept pending, then regulation says
that a subdivision officer has to take premium from me and the land will be considered diverted.
on the mere application for diversion.
Yes, that's what I'm submitting. Rule 4A, Your Lordship. Sir, regulation. It is under the rules, Your Lordship. 4A,
Of 1966 regulations,
1968 rules.
rules.
Yeah.
1968, just a minute. 68 rules. Is it Andaman and Nicobar Administration Chief Commissioner Secretariat? Andaman and Nicobar Islands Land Revenue and Land Reforms Rules 1968.
Yes.
Rule then chapter 2 says disposal of trees.
No, it's 4A. Disposal of trees, yes, under that
Yes,
heading only.
disposal of trees.
Then
Chapter 2.
after that, next page, diversion of land use.
Yes, yes.
4A1. Any tenant holding land for any purpose may apply to the subdivision officer for permission to divert all or part of the land in his holding for any other purpose in Form A. I will take you not
In his holding.
Yes, this is in his holding. No doubt.
That,
about it.
with regard to the diversion which you have prayed for, that is under your holding.
Yes,
So how this land is being utilized now as a for cultivation?
it's only jungle type. Basically. It's jungle, basically a jungle.
So at the time of making first application for diversion, why you have not prayed for diversion of 2000 square meters?
Because I felt, Your Lordship, within 1000 square meters, I would be using it for resort. Rest, like a forest, it may be. I don't want that entire area.
So you
to
want
come
that
into
the
resort.
agricultural land to be converted into commercial land?
Yes,
So that
not
was
entire one.
that was restricted to 1000 square meter with regard to your first application.
First application.
Now you want another 1000 square meter to be diverted from agricultural to commercial.
Yes,
Just a minute.
yes.
But it is under your holding.
There is no dispute to that fact.
Now, whether the a subdivision officer has taken steps on inquiry and forwarded it to the chief commissioner under rule 4A2,
Like
rule 4A2.
4A12 is applicable in respect of grant. This is not a grant. This is not a grant. See, kindly read that entire one. The subdivision officer shall cause an inquiry to be made and shall, unless he rejects the application for reasons to be recorded in writing, forward the application along with the report of the inquiry and his own recommendation to the chief commissioner through the deputy commissioner for making grant under clause 1.
Yes,
Third one is applicable here.
under for making a grant under
Grant.
clause 1.
Grant is different. Third one is applicable. For us, third. This is the criteria. This is for grant. Grant is like a lease.
But the right is there, so far the subdivision officer is concerned as delineated under rule 4A 3 A, B, C, D.
Yes, I'm not further. A, B, C, D,
Since
E, F, G.
relates to grant, excluding 2, if 3 is considered
Yes,
for diversion.
yes.
In that event also the subdivision officer has the power to
Of
take
course,
steps
but I'm
accordingly.
not disputing that. A to G, the authority has got the power to deal with the issue. Now, 4 may be seen, where an application last 4, where an application of land use in any holding is not rejected by the SDO, he shall, on deposit by the applicant of the premium, if any, determinable under these rules, allow such diversion in accordance with the terms of the grant made or license granted in pursuance of the recommendation made in sub-rule 3.
But rule 4, sub-rule 4 says that allow such diversion in accordance with the terms of grant,
Or,
which is relatable to sub-rule 2.
or license.
Yes, but it is not diversion.
No. Grant or license means.
No, he has just now submitted that the sub-rule 2 is not applicable since
Yes,
it relates
this
to
is
grant.
license. Word is license is also issued. I am a licensee.
No, your application is for grant for diversion.
Diversion.
So
for-
how rule 4, sub-rule 4 comes in your aid?
Because it is in respect of grant as well as license. I am a licensee. In
Now,
respect of agricultural land.
whether the subdivision officer has taken any decision in terms of rule 3, sub-rule 3.
No. square meters, they have diverted it for commercial purpose.
Right.
Without taking permission of the estate. So, my lord, there was a stay order also issued to, my lord, RC case was initiated in 2024, my lord, to stop further construction. Even stay order was issued against to stop the construction work, because without diverting the land, they.
So according to the petitioner, which it is submitted, that there are two phases of diversion, as it has been prayed for by the petitioner. In first phase, there was an application for diversion to the extent of 1,000 square meter. Now this was permitted and it was diverted, and this land is used for commercial purpose. 1,000 in two phases, 500 plus 500.
Yes.
So it was permitted and the land in question was diverted and it was used for commercial purposes. Now there, apart from this 500 plus 500, another 1,000 has been prayed for.
But on inspection, it is found they're already using it for commercial purpose without.
The land which has been prayed for diversion in the third phase without permission.
Is this can be a ground for the purpose of.
How you can do this?
Your Lordship, that they have the authority.
Then the entire procedure becomes nugatory.
No, Your Lordship, let me explain this. This we are disputing it. We are not admitting this particular thing. Because area they have not measured. They don't know whether it is only one.
There is a dichotomy in your submission. There is a dichotomy in your submission, is not.
Your Lordship.
In one hand, you have prayed for diversion, and in other hand, when on inspection, it is found that the land in respect of which diversion has been prayed for in the third phase is already being used for commercial purpose. Then what is the use? What is the purpose of making an application for diversion?
Application for
Have
diversion.
you stated it in your affidavit in opposition? Yes, show me.
I have disputed that fact, Your Lordship.
Yes. Show me. This Swarajdeep means Neil Island.
No.
Havelock. Yeah.
I have explained in detail, Your Lordship, what the authorities have done.
Just a minute. How you have dealt with paragraph 8?
Yes, Your Lordship, I have dealt with
Yes.
it. Line. I have already stated.
Just a minute, just a
Your
minute.
Lordship.
Have you made an application for premium, payment of premium
Yes. It is.
in
it is-
connection with your last diversion application?
Yes, Your Lordship. It is in the Form A. Form A is for that purpose only.
So therefore, according to it is automatic.
No,
If the
no,
application
no,
is
no,
kept pending.
No, no, Your Lordship. I am not saying that. That is my alternative submission. My first submission, the illegal diversion about which they are speaking about, Your Lordship may kindly come to paragraph 10. It is not that I have improved afterthought. Paragraph 10 of my writ petition.
It is disputed question of fact.
No, no, no.
I have not gone to make an inspection.
That's what, Your Lordship. What I am saying is
Yes, let us please come to paragraph 8 of their affidavit in opposition.
8 and 18 both.
Please come to paragraph 8.
Coming.
Yes, page 6.
This 6 I have come here.
Yes, yes, yes.
Yes, they
Please,
repeated.
please read it, Mr.
No, no.
Mishnah.
I am reading.
Don't hesitate.
No, no, no.
Yes, yes.
Para 6.
Yes.
Say
No, no, para 8.
8. That the averment made in paragraph 5 of the writ petition is denied and disputed. It is further submitted that recorded tenant has illegally diverted an area of 1,000 hectares out of land bearing survey number this at Vijayanagar village under Swarajdi within Port Blair Tehsil, against which stay order has been issued by the court of Tehsildar on this with their RC number this to stop further construction till the permission obtained from the competent authority, as recorded tenant has violated the provision of this land where also attract the provision of clause B subsection 1 of section 151 of the Andaman Nicobar Land Revenue Land Reforms Regulation 1966. Moreover, the recorded tenant has requested for diversion of an area of 0.5 hectares of land bearing survey number this Vijayanagar under Swarajdi within Port Blair Tehsil for commercial purpose on this, against which the notice has been issued RC number this for appearance on this inter alia direct to furnish the utilization of land with regard to land already diverted into commercial site, but omitted the same by the.
Now, yeah, how you have dealt with,
Yes.
come to paragraph 9 of your reply.
Yes. In this connection, it is stated that there has been no.
No, the contents of paragraph 8, yes.
It is
In this
that-
right. In this connection,
It is stated that there has been no illegal diversion because in terms of 4A of the Andaman and Nicobar Islands Land Revenue and Reforms Rules 1968, the application of the applicant has not been rejected and therefore the subdivision South Andaman has to receive premium from the petitioner. Please-
so according to,
Yes.
therefore, it appears that the statements or averments you have made in paragraph 9, it appears that it is automatic.
Your
If no decision is taken.
Lordship, that's what I am submitting. I started the case itself in that manner only because the petitioner has construed regulation 4A.
When you have made application for diversion,
2020. 5 years have passed. First 2019, then 2022. 2 applications are there. My applications are, they have issued notice also. It's not that they have not issued notice. Kindly come to page number 21 of my writ petition.
Now, only one thing, Ms. Das, why under subsection, why under sub-rule 3, decision was not taken? When there was an application, rightly or wrongly, if any application was made, then it is the duty of the SDO under Rule 4A, under Rule 4A, sub-rule 3 to take decision. Taking into consideration the factors which have been delineated under sub-rule 3A to G.
Instead of like their application, during the pendency of the application, before that, they have started the construction in agricultural land. I have stated in para 16 a lot, it was for agriculture, that particular land is suited for agriculture purpose, and they have constructed the RCC building construction. For that reason, RC case was initiated and a stay order also was issued by the Tehsil. Maybe for these reasons, since matter is pending, because an application is still pending. Because
That application for diversion was still pending.
both the applications are pending.
What is the outcome of that RC case?
Still pending. Your Lordship, may I submit it?
RC case is pending before whom? Tehsil.
Your Lordship, may I submit one thing?
So why you are not contesting the RC case before the Tehsil?
It's going on. I'm contesting. I have specifically said that's what I.
Then
just don't want
Ms.
to stop
Ms. Nath, do one thing can be done, that let the RC case be concluded.
That will be concluded.
Today, if court passes an order on this writ petition, then this RC case will become an OSHIO.
No, Your Lordship. The court will never direct the subdivision officer to divert the land. Can the court do it, Your Lordship? I know the court cannot do it because a decision has to be taken by the subdivision officer himself, whether to divert the land or not. The peculiar thing, why I am cutting, otherwise, Your Lordship, in the beginning itself, the matter could have been disposed of by directing the subdivision officer to consider my representation.
But that phase is over.
That phase is over. Now, the problem here occurred, Your Lordship, in their affidavit in opposition. Kindly, Your Lordship, give me 5 minutes, Your Lordship. I want to clarify this thing.
Have you indicated the particulars of RC case?
It is there.
Where? Oh, yes. Paragraph 8, RC number 42949.
That RC case has got nothing to do with my diversion, Your Lordship. They cannot. Tehsildar does not have the authority to interpret 4-1 this thing. Just a minute, let me complete.
Spot inspection on that spot.
No.
I found that
2020, Your Lordship.
constructing a building in an agricultural land.
Your Lordship, let me make my submission, Your Lordship. Thereafter, let her make submission because I want to clarify this thing. Your Lordship, my application was in 2020. My another application is in 2022. Now, Your Lordship, the RC case, what about which they are speaking, that is in 2024. My applications are pending. This is my interpretation in respect of 4A1, that last one. The premium is to be collected and thereafter, Your Lordship, it will be diverted.
It cannot be automatic.
No, what 1 minute, Your Lordship. I can assume one thing, Your Lordship, that the petitioner has made an afterthought if in the reply, Your Lordship, he has made a certain averments. Now, kindly come to my writ petition, paragraph 10. What I have stated. And I will satisfy this honorable court with regard to that. Paragraph 10 may be seen. That after obtaining approval of 1,000 square meters of land diverted into commercial and building plan in respect of the said land, the petitioner started the construction. He has completed the construction of 12-room reception 3 villas on the said 1,000 square meters of land. This is no dispute. It is pertinent to mention here and then when the petitioner purchased the land, some part of the land contained coconut plantation. In order to complete his project, the petitioner had to construct a kitchen and restaurant. He has been waiting for more than 4 years and ultimately decided to build a structure which can be used for the purpose of stacking coconuts and at the same time can be converted into kitchen restaurant after the order of diversion. That was playing in his mind. Now also, even today, if Your Lordship is going to order for an inspection, if kitchen and restaurant is running in that premises, Your Lordship can pass any order if Your Lordship wants. Stay order has been passed after much time, what you are telling.
That's why there was no further construction.
See, that is incorrect, Your Lordship. That is incorrect submission. I have specifically stated in my petition itself. It's not afterthought. That is in reply I am stating. And now, Your Lordship, I want to show.
Just a minute. Miss Nag, please come to your prayer B. Page 11.
Now it is, that was.
It goes to show that there was a construction.
I'm not disputing.
You have paid for status quo, that's all.
Disputing construction. Your Lordship, I have stated.
No.
Your Lordship, kindly, paragraph 10 of my writ petition. Your Lordship, let
Yes,
me complete.
please
Your
take down. Yes, I have
Lordship.
added.
Let me complete, Your Lordship.
No,
Your
sorry.
Lordship, I have to show the provisions. Your Lordship, kindly. I have to show the
Yes,
provisions.
please take
Thereafter, Your Lordship can pass any order Your Lordship likes.
I have heard it.
Your Lordship, kindly, regulation
Sorry.
157, Your Lordship, may kindly come. Your
Uh,
Lordship, I want to show certain regulation.
Matter is heard in presence of the learned advocates representing the petitioner. And response on after exchange of affidavits. Stop. The grievance which has been pointed out by Ms. Nag, learned senior advocate, representing the petition is in spite of making application for diversion of land, which is under the holding of the petitioner, measuring 0.1000 hectares. Situates under survey number 36 at Vijay Nagar village under Swaraj Deep within Port Blair Tehsil. Same was not the said application was not decided in terms of rule regulation in terms of rule 4 capital A within bracket 3 of Andaman and Nicobar Islands Land Revenue and Land Reforms Rules 1968 within bracket hereinafter referred to as rules of 1968 close bracket. It is strenuously argued by the it is strenuously argued on behalf of the petitioner that due to failure on the part of the concerned subdivisional officer to take decision on the application made seeking diversion of the land as alluded above, in terms of Rule 4, capital A within bracket 3. Rule 4, capital A within bracket 4 comes into play, which makes the petitioner entitled to use the to divert the land on deposit of premium, which is determinable under the relevant rules in order to allow such diversion. So, in other words, it is submitted on behalf of the petitioner. Failure on the part of the concerned subdivisional officer to decide the application for diversion of the land permits the petitioner to get the benefit of diversion in compliance of Rule 4, capital A within bracket 4 of the said rules of 1968. Stop. Stop. It is further submitted. In the event the application for diversion is kept pending, which has been made under Rule 4, capital A within bracket 1. Permits the applicant to get the benefit in terms of the provisions as contained under Rule 4, capital A within bracket 4. On diversion of the land in question. Next paragraph, it is further it is also contended that previously on 2 phases, applications made by the petitioner for diversion of the land from agricultural land to commercial was allowed, which enabled the petitioner to construct a resort, and further diversion is required to the extent of
1,000 square meter, 2 applications.
0.1000 hectares for expansion of the said resort. Next paragraph. Prayer is made on behalf of the petitioner during course of argument that a mandamus is required to be issued directing the concerned respondent authorities on compliance of formalities as envisaged under Rule 4 capital A within bracket 4 of the said rules of 1968. Please read the sentence.
On conveyance of formalities as indicated under 4A in the four of this rule.
For use of the diverted land for the purpose of expansion of the resort. Next paragraph. Ms. Das, on the contrary, Ms. Das, learned advocate representing the respondents on filing affidavit, has disputed the case made out in the writ petition, and in this regard submitted that the concerned authority or the SDO made the inspection, Ms. Das? Tehsildar. That the concerned Tehsildar on inspection found that the land in question for which, in respect of which diversion application was pending before the subdivisional officer, was illegally diverted and construction was going on, which prompted the concerned respondent authority to issue stay order on 21st June 2024 on initiation of RC case being number 1297 slash TPB slash 2024. So it is further submitted that the said RC case is still pending for final adjudication. Stop. Next paragraph. On perusal of the affidavit in opposition, on perusal of the averments made in the affidavit in opposition in paragraph 8, or on perusal of the averments made in paragraph 8 of the affidavit in opposition, vis-a-vis the averments made in paragraph 9 of the affidavit in reply, it is found that in reply to the stand taken by the respondent authorities in paragraph 8 of affidavit in opposition, there is formal denial. There is mere formal denial of raising there is mere formal denial of illegal diversion of the land without strike of without. Formal, there is formal denial of illegal, there is formal denial of illegal diversion. Stop. What is striking, as it appears from the statements made in paragraph 9 of the affidavit in reply, that the statements are made to the extent since application for diversion was not rejected, the concerned subdivisional officer is under obligation to receive premium from the petitioner. Stop. Next paragraph. On perusal of Rule 4A of the said regulations of 1968, it appears that under Rule 4 capital A within bracket 1, right is conferred upon a person who is enjoying a piece of land to make application for diversion. And procedure has been delineated under Rule 4A within bracket 3 within bracket A to Rule 4A within bracket 3 to within bracket G, that what are the conditions which are to be taken into consideration in order to allow an application for diversion of lands. Stop. Stop. At the same time, Rule 4 within the Rule 4 capital A, Rule 4 capital A within bracket 4 provides in the event there is no rejection of application seeking diversion, the subdivisional officer on deposit of premium as determinable under these rules allow such diversion in accordance with the terms of the grant made or license granted in pursuance of the recommendations made in sub-rule 3. Therefore, reading of the entire sub-rule 4A reveals a situation that on making application for diversion under rule 4 capital A within bracket 1, an exercise is required to be made by the subdivisional officer in terms of rule 4 capital A within bracket 3. And in the event after such exercise it is not rejected, the application for diversion is not rejected, then on deposit of premium as determinable under the relevant rules, grant or license should be accorded pursuant to the recommendations made in sub-rule 3. Stop. Therefore, the steps which are required to be taken under sub-rule 4 is not an isolated step or is not an isolated incident ignoring the exercise which is required to be made under sub-rule 3. Next paragraph. In the present case, disputedly and indisputedly, no exercise has been made under 4A1 within bracket 3 of the said rules of 1968. Therefore, straight away invocation of rule 4A within bracket 4 is not is impermissible. That too at a stage when premium has not been determined. Stop. On the contrary, it is found from the statements made in paragraph 8 of the affidavit in opposition that on inspection, Tehsildar found that the petitioner in his own has diverted the land in question and started construction, which is corroborated from the prayer made in the writ petition or from the prayer, yes, from the prayer made in the writ petition or which is corroborated from the prayer B as made in the writ petition, wherein petitioner has prayed for maintenance of status quo. In connection with the land in question, based on application made for diversion. Stop. Next paragraph. In view of aforesaid scenario, till conclusion of RC case number 1297, means that's 1297/TPB/2024, petitioner is restrained from taking any steps based on no, 2024, no order would be passed at this stage. And at this stage, the writ petition stands dismissed. Stop. The concerned authority is directed to conclude the aforesaid RC case as within which time you'll be able to conclude it.
My applications also, those are also pending.
There are also this RC case which is pending before the authority.
2024 you have initiated.
Her application is pending.
My applications of 2019, you started in 2020.
So RC case has to be concluded. Within which time we'll be able to conclude it? By 2 months?
3 months.
Your Lordship, just a minute, Your Lordship. They have themselves have stated that you should stop construction till the permission is granted by the subdivision officer. They themselves stated. So first the permission wala issue that is to be decided. Then only this thing is to come.
Conclude the RC case by 90 days from the date of communication of this order. Stop. After the final order is to be passed in the RC case, petitioner shall be at leave to take steps in accordance with law, if so advised.
Your Lordship, my submission may be recorded, Your Lordship. My submission in paragraph 10 of my writ petition, para 16 of my reply, that may be recorded. That's what I want.
At opore diye debo.
Your Lordship. Paragraph 10
Learned
of my
advocate
petition.
representing the at the relevant paragraph before where I have considered the submissions of Ms. Nath representing the petitioner. Submissions have also been made on behalf of the petitioner, relying upon the statements made in paragraph 10
and
16.
10 of writ petition.
Paragraph 10 of writ petition and paragraph 16 of the affidavit in reply.
Your Lordship. Your Lordship. I'm just making one small prayer, Your Lordship. Direction may be given to the subdivision officer to dispose of my representation. Applications are pending. That also can be given.
If I do this, then my entire order will be considered as bad order. Because let the RP case be concluded.
Both things will go together.
এটা একসঙ্গে পাঠিয়ে দেবো।
Your Lordship, last. My submission will be recorded, Your Lordship, that I have sought for disposal of my application pending before the certificate.
No, sorry.
My submission, it's my prayer.
Oh, the next line, next line.
Prayer.
Uh, prayer is also made during course of hearing on behalf of the petitioner to dispose of his application, to dispose of, to dispose of the application of the petitioner seeking conversion.
Yeah. Online.
কত নম্বর হলো এটা? 76.
76.
Rest of the matters will be called on tomorrow. Very well. It will retain its position in the.